Within 30 plus one of judgment.
Dismiss.
May I please lordship? My lord, one I has been filed yesterday in connection with the item number 11 of today's list matter. So that may be my call for because we have filing and implementing
11.
11. That will be taken at 2.
Wait, please, my lord. My lord, in item number 5, my lord, we filed an additional affidavit, my lord, bringing on record certain subsequent developments. That affidavit may kindly be called deeply.
May I please lordship? One motion matter lordship. We have filed it yesterday lordship. May I pay for listing tomorrow lordship? Some offenses.
Well, item number 8, my lord. It's a PWD matter, my lord. Here we are yet to file an affidavit. I can file it by, say, my lord, Monday. Can it be on 17th of December, my lord, as agreed by the other side?
You're for the PWD.
Yes, sir.
What about respondent number 5?
Lordship, on the last occasion, as per the order, Your Lordship, we were supposed to take dusty service, Your Lordship. We had taken it. We have filed the affidavit also. However, it was refused by respondent number 5 here, saying that he has already received the copy from the registered post issued from court. However, the office note does not reflect that the card
Has been returned.
Service, you know.
What about his prayer that it should be taken up on 17th?
Yes, Your Lordship.
17th of
This is
December?
the agreed date, my lord. They proposed 17, my lord.
Oh, they have proposed 17th. Okay, let's bring the file. This is regarding every 3 of them being L1.
Yes, Your Lordship.
Okay, right.
Regarding, my lord, rejection of the beat of the technical beat of the petition
Petitioner
on
and-
5 grounds.
Yes, and the acceptance of the bid of.
Okay, that one. Okay, right. Mr.
KJ Sakya.
KJ Sakya appearing for the petitioners. Says that the matter may be listed on 17/10/2020, 17/12/2024. So the same is not objected to by Mr. B. Gogoi, learned counsel for the PWD, who submits that affidavit in opposition will be filed within
My lord, by Monday.
within a week.
Within a week.
Full stop. Anyway, an affidavit of dusty service on the respondent number 5 has been submitted, stating that the respondent number 5 refused to accept the notice on the ground that he had already received a copy of the writ petition through registered post sent from the registry. Full stop. Next file. The above being said, the office note dated 22/11/24 states that there is no return of AD card or unserved notice from the respondent number 5 in respect of the notice sent through registered post to the respondent number 5. On considering the fact that notice had been issued to the respondent number 5 through registered post only on 6/11/2024. Await service report. List the matter on 17.
Lordship, there is an interim on the technical.
Interim order to continue till the next.
Thank you.
Wait, please, Mr. Lordship, my lord, in respect of the item number 12, my lord. Yesterday we have filed an adjournment. Senior counsel, my lord. Mr.
Item 12. Okay.
My lord.
Why do you want adjournment?
Senior counsel, my lord, Mr. G.N. Savala, out of station.
Out of?
Station.
Adjournment prayer has been made on behalf of Mr. G.N. Sayawara, learned counsel for the respondent number 2. Accordingly, release this matter when?
And,
You're for whom?
I'm for respondent. 12. My lord, after 1 week, my lord,
This is the matter after a week.
obliged.
May I please, your lordship, with the consent of the other side, I may beg to mention item number 9,
9, again adjournment. For whom?
for KP Pataki, due to personal difficulties, he could not appear.
Okay, okay, right. Mr. Sahewala is ready?
No, my lord, he's out of state, my lord. That's
Right. On the prayer for adjournment made on behalf of the counsel for the petitioner and the respondents. List the matter after a week.
Much obliged.
Please, your lord. I beg to mention for listing one WBC for admission, lordship.
Date, next week.
Public.
I like it. May please, your lordship. Before I start, my lord, although I'm aggrieved by the arbitrary rejection of my technical bid, last evening my client had called me up and said that the financial bids have been opened. My bid is not known to them because they have not opened it. But to be honest, I would come as L2 and not in the fray.
Okay.
I would come as L2 and not in the fray. Therefore, one view of the matter might be, I do not affirm that it's academic. And the other view is that my cause of action survives. It's a pleaded case. That if once blacklisted is blacklisted forever,
No, you cannot be blacklisted forever.
then the concept of blacklisting, as has been understood by the respondent authorities, is ex facie illegal,
Correct. Provided,
provided
what was the information sought for? And did you give,
correctly.
did you,
My lord
did
comes
you
at page 31
specifically?
of the writ petition, 28 of the writ petition, my lord,
28.
28.
Yeah.
Please submit document related to declaration of bidder confirming that the bidder has never been blacklisted in any government institute, organization, or PSU. Now, OEM is not a SAR, that's original equipment manufacturer. 29. We had uploaded this document. May I place it, my lord?
Yes.
We would like to take this opportunity to clarify that our organization's status regarding the past blacklisting issue. Our organization, Eastern Technology Group, was blacklisted by IIT Guwahati in 2012 for a duration of 3 years. Following this period, we were successfully delisted and have since maintained a positive and productive
Now,
business.
just a minute. When was the last date of submission of your bid?
19th of September,
19th of September. Okay, okay. So,
1300 hours.
so it was prior to that.
No. 19th of September, we did it. They chose to open up the issue on 7th of November.
No. The last date of submission of your tender,
We have given acknowledgement. If those things are clear.
those things are clear.
Clear. They cancelled our bid, page 33. They sought clarification again to be doubly sure. We never shy away from the fact that yes, there was an episode of blacklisting ours long back, and IIT Guwahati I'm working till now.
No, just tell me, what about this page 30?
30.
Yes.
Oh, 30. 30 is additionally.
Huh?
Additionally. We just gave it. It has nothing to do with tender document.
But section 30 is basically dodging the bullet.
No. We have not. This is not even a part of the document.
Okay.
We
Then
just-
why did you put it here?
No, we put it here because 7-11 when they came, I uploaded page 29, 30 I'll get this thing. To be in the fairness of things, I put it this way. This has nothing to do with the rejection
It
or
has got
cancellation. Nothing to
no
do.
relevance.
Nothing to do with that.
Then why did you put it in there?
We did it. We did so.
Mm.
If I plead so, I may next so. It has nothing to do with the acceptance or rejection of my bid. But I did it. Page 33, they come up with a view that past, blacklisted in the past, so we did not. Of course, even if I win the case today, I cannot secure that thing I say. But my entire life and livelihood is at stake, my lord. Every time it would happen. And if I take a call against me also, my lord, was I late? I put that question to myself. Friday afternoon, gentleman comes to know, runs to my chambers in the evening. Saturday, Sunday could not do yesterday. Before filing, I made a mention with all fairness that we have not filed it yet. And we got it listed today. Interregnum period evening, they opened. Now, it would not make a change. Even if they would have not opened, I would have not prayed for a stay.
But your future action.
Absolutely, me. Notice and no more for the present.
Yes. Who's for the other side? Who's for the authorities?
Now since my learned.
He's a formal party, my lord.
Huh?
He's a formal party.
Who is the main party?
Government of Assam Education Department.
Huh?
He's a education department, higher education.
Higher education department.
Who is for the higher education?
It's only as an institute.
You're the main
Except
person.
nothing to do.
Yes, Mr. Counsel. Can a person be blacklisted forever?
Lordship,
Huh?
Lordship, it's notice may be issued, Lordship.
No, I'm
Yes, sir.
asking you.
That's true, Lordship.
Huh? Can a person be blacklisted forever? The blacklisting order in regard to the petition is only for 3 years.
Lordship,
That period has expired.
yes, Lord.
Now he starts off with a clean slate. You cannot keep on, revisiting him with the issue that has already been finished. Already, that water has gone down the bridge.
Lordship, notice
It's
may be
like saying, it's like, putting him in jail all over again.
issued. This is notice, I will highlight it.
Of course, nothing survived.
That's-
This,
Still-
but this
still-
for his future, for
Still-
pure participation,
Yes, Lord.
then it'll affect him.
Yes.
Or it may be disposed of at the motion stage a week later. Let him have the instruction as to what prevailed in their mind for having such a clause. That would meet their.
Yes,
We will not think to lengthy because I am not claiming a stake anyway.
Correct.
Let him commit for motion next week, Mr.
Lordship, notice may be issued, Lordship.
No, it is no, gainsaying the fact that we delayed the matters by affidavits and all. Only on the short point, nothing more. I do not seek to gain it.
That is
I do not
notice.
seek to gain anything.
Notice for what?
For what, Mr.
Just for adjournment?
Lordship,
No, it's a very small point.
Lordship, Lordship.
Next day for motion, Mr. Any day.
Just a minute. Let him try to understand the point. The issue is this. You want to know whether he's been blacklisted earlier. He says he has been blacklisted earlier for 3 years. That period has expired in 2015. Now he has participated in a tender notice and you have disqualified him on the ground that he has been blacklisted
Yes,
earlier.
that's
That cannot be.
That's what point, Lordship. Yes, Lord.
Nothing survives. He cannot get it.
Lord.
Of course, if L3 is given, then he's got a case. But we do not
I'm
know
not
if.
disclosing the figure, but I know that I am L2 now, so I would not get it otherwise.
Anyway,
What instruction?
942.
There is some confusion. What instruction he will obtain because he is already admitting that he's L2. So.
No. What instruction he'll obtain is. You see, one thing is this. His instruction is whether he was disqualified, whether petitioner was disqualified for the blacklisting order passed against the petitioner in 2012.
No, that's admitted.
It is admitted law.
Admitted by them.
Admitted.
This is the last annex.
Then what is there to
Nothing to
decide?
decide.
Last annex. page
Only
number
this
33.
proposition is bad in law.
If he is aggrieving a future action, he can.
No, that's a wrong way to establish the fact, my lord.
Then
That's
again, the
exactly
same
wrong.
issue, the same issue will come out.
Because same issue would come up, my lord. I'll miss the past. N number of tenders have been floated.
So basically the issue is he'll take, why shouldn't this impugned order rejecting the petitioner's technical bid should not be set aside,
Regardless of the fact that I may not get it.
regardless of the fact that it.
I'm not paying for anything more.
That's all.
That's all.
The only issue is whether blacklisting order can survive.
Yes.
For till his death. When it is only for a period of 3 years.
Yes.
That's all.
That's all. I'm grateful. Obliged.
Heard Mr. S. Banik. Learned counsel for the petitioner. Who submits that the petitioner participated in a tender process. Pertaining to bid number GM/2024/B/5334802 dated 28/8/2024 for procurement of desktop computers bracket Q2, hereinafter referred to as DNIT. in the bid documents, comma, the bidder was required to submit a declaration that the petitioner had never been blacklisted in any by any government institute slash organization or public sector undertaking. The petitioner thereafter submitted a letter dated
8/11,
8/11/2024
uploaded on 9/11.
in person to the NIT, which was uploaded prior to the last date of submission of the.
After submission of bid, they raised a request on 7/11. Page
Okay,
28.
after, okay,
They
forget
raised a
that,
request. we
forget that,
refused.
then what have I said? Huh. Yeah. Which was uploaded? First up. The said letter dated 8/11/2024 stated that the petitioner had been blacklisted by the Indian Institute of Technology, Guwahati in 2012 for a period of 3 years. The period of blacklisting having been over after 3 years, the petitioner was thereafter delisted from the blacklisting. Blacklisting order, blacklisting.
No, do not
Black-
order, but we work.
Was delisted. Delisted. The petitioner's grievance is that the state respondents have rejected the petitioner's technical bid only on the ground that the petitioner had been blacklisted in the year 2012. Next para, the petitioner's counsel submit that that as the blacklisting period had been over in the year 2015, the stigma attached to blacklisting of the petitioner could not continue beyond the year 2015.
Or the operational period of blacklisting.
That's it.
That's it.
2015. Full stop. Next para. Mr.
As Bhuyan,
S. Buya appearing for the respondent number 1
one, say higher differently.
shall obtain instructions as to how the petitioner could have been, how the petitioner's technical bid could have been rejected on the ground that the petitioner had been blacklisted. On the ground that the petitioner had been blacklisted in the year 2012, which has been, which period had expired by the year 2015. Leaves the matter on when? Next week.
Next week.
Motion.
Huh?
For motion.
Naturally. I have not said the issue notice.
Yes. No.
It's a small issue.
No, Sita. Fine.
Yeah, first up, just say one more thing. He shall also obtain instructions and produce citations, if any,
Yes.
to show that a blacklisting order which has lost its effectiveness after 3 years can continue,
In perpetuity.
Huh?
In perpetuity.
can continue in perpetuity.
Grateful.
So you bring that, that's all. If you succeed, writ petition dismiss. Yes.
May I please? My lord, the respondent number 3 has filed their affidavit in opposition, wherefrom it appears that they have reduced the requirement of brightness from 500 to 390. But then another condition remains that a SIM lock has to be provided in the PCs to be submitted. That SIM lock also only Samsung Electronics can provide. But then my learned friend has said in his affidavit that if any representation is submitted by any if any representation is submitted by any other dealer on behalf of any OEM, that is original equipment manufacturer, they will consider. And accordingly, my OEM, Acer Electronics, they have submitted a representation on 4/3.
4/3?
4/3/2024. Their bid was published on 11/3. So they can consider my representation. Even earlier,
Bid was
bid was issued on 11/3.
NIT, you mean, was issued?
Yes.
Huh.
And on 4/3, my OEM, original equipment manufacturer,
You mean prior to the bid being issued, you
Yes.
submitted a,
representation.
how can?
It was issued on 1.
Sorry, 1/3. So I'm sorry, Lord. On 11/3, on 4/3, we have submitted a representation.
With regard to the lock.
Yes, on to the respondent number 3. I have
So
furnished
where is the decision on that?
My lord, in fact, today he has served the copy. My
My lord, I got it yesterday. I got an instruction yesterday.
It's not-
This is a copy.
It's not there in
Even
the,
then, I can have the instruction because only my lord, that particular criteria is there, my lord, which they feel that it should be struck down. And then if a representation is there, we can definitely look into it. And so
let
for
us see the prayer of the representation.
Lordship.
You have only asked for recalling the letter dated 21/2/24 and bid document number. This is with regard to the brightness only.
Yes.
But now new point they.
Now new issue.
It is already there in the pleadings, Lordship.
Okay, where?
Lordship may kindly see page. This is there, Lord. Lordship, page 73.
73. Yes,
That is clause 5, specification of MDM.
yes,
Lordship, then E, 5E.
yes,
SIM lock,
yes.
specific department
No,
authorized.
that is in the tender. Where is your averment?
I have said so in my affidavit in reply, Lord.
Now since we have brought down that brightness part, now say they say.
Okay, now he's brought a new issue in
And
that.
Lordship, for my instruction take from the technical expert of our department, they say that, madam, this is a software. It's not
Okay.
something, it's not a part that it's a Samsung can manufacture. It's a software. And they are going to give a assembled mallet tablet. It's not that they have a brand. They will assemble it. So they can.
No, I will-
incorporate it. He may also have the instruction whether he can.
Not, Lordship, will not be assembled. Our OEM is Acer Electronic. We will supply Acer brand product.
Acer.
Yes.
So-
ACER.
I know.
Yeah.
But then if it's a software, why don't you
Yes,
put it into your system?
for this particular supply, but if at all he is successful.
We will record a submission that it can be put as a software.
Lordship, that instruction I don't have. Let me get that.
He's telling you that he's permitting you to put the software into your product if you get the tender.
No,
Lordship,
we will-
whether,
well, they will have to give.
whether that,
Huh?
They will have to give that product along with the software. of-
whether that
It's a
is
SIM lock,
technically,
it is
whether
otherwise
that is
necessary.
technically
Feasible.
feasible or not, I don't know.
Yeah,
I'll have to
let it be
obtain-
instruction,
I'll have to
let
obtain
them-
instruction.
instruction.
Yes.
Thought that, my lord, 1 or 2 days, let it be, my lord, on Thursday.
On Friday or Thursday.
Only on
Thursday.
that point, my
On
lord.
Thursday.
Otherwise, Lordship will consider the representation if Lordship allows.
Okay, where is it in your affidavit in opposition? Where you have said
reply.
regarding the brightness and everything?
Yes, yes.
Page 158, I think.
Lordship.
Starts at 150, oh, no, my lord, 167.
167.
167. paragraph
167.
five. Yes.
No, this is his submission. Where is your submission in your
Yes,
affidavit?
Yes,
Yes,
he,
in
he
there
has,
it happened.
he has said that in page 158.
That's what I'm saying.
They are not true. Well, 158, the Second para.
Okay, right.
Joseph, I have filed, my OEM has filed a representation that may also be considered. This is the representation.
Is it part of the records?
That is not in the record.
And lots
I
of
got it
consider
yesterday,
that
Lord.
We can save the time. I will also have my instruction. on this.
Okay, you give me a
Yeah.
Yes.
Waiting for respondent number 2, I have not received a copy of affidavit in opposition filed by the.
Please
That-
give him.
Yes, my lord, I will serve it.
Ah.
Yes, sir.
He's,
you want-
yes, please give him everything.
My lord, my lord.
Okay, right. Heard Mr. P. Bhumi for the petitioners, Mr. B. Gogoi for the SSA,
Yes, respondent 3.
and Mr. D. Huh? Rathi. D. Rathi for the respondent number 2. The petitioner's counsel submits that para 9 of the affidavit in opposition filed by the respondent number 3 is to the effect that the brightness of the tablet PC with MDM software has been lowered from 500 or 600 to 390 NITS or higher. Yes, sir. However, there is a new requirement of the bidders requiring to put a SIM lock.
Yes.
SIM lock in the PC tablet.
In the
In the
PC.
In the PC tablet.
Lord.
Full stop. Next para. Mr. B. Gogoi, the learned counsel for the respondent number 3, submits that as per oral instructions received by him,
My lord.
the SIM lock is basically a software which can be inserted, which can be uploaded, installed,
Right.
which can be installed in the PC, in the tablet PC. Then Mr. P. Bhumik shall obtain instructions with regard to the above. List the matter on.
On this representation of the lordship will indicate in.
Before that, Mr. shall obtain instruction on the above. So Mr. P. Bhumik also submits that the petitioners had submitted a letter to the respondent number 3.
Lordship, not the petitioner, the petitioner's OEM.
The petitioners OEM
Yes.
had submitted a letter dated 4/3/23 to the respondent number 3.
In third column, my lord. In the middle, primary law SIM.
For changing the requirement of a primary SIM lock in the tablet PC. However, the said representation has not been decided by the respondent number 3 till date. Next, Mr. B. Gogoi shall obtain instructions with regard to the status of the petitioners, status of the representation dated 4/3/23 submitted by the petitioners OEM by the next day. List the matter on
Friday, but it's
Friday.
if possible, yes. On
Friday or Thursday, Lordship. Friday is a.
Thursday, day after tomorrow.
I guess so.
I don't
I have
know.
no issue.
Okay, you can, Thursday. It's a small issue now,
small
there's nothing remains.
Problem.
Wait, please, your lordship. This matter, basically, we are challenging the order of the Anchalik Panchayat, setting aside the settlement of the petitioner after the order of the government, which has the notification of the government, which says that the subsequent, your lordship, without the earlier basis should continue. So they cannot override the decision of the government. Now, that's the first point which has to be decided. Now, what has happened? There are many matters which challenge the government notification in a series of matters. Those matters were heard by Justice Devashish Borua, and the matter is CAV now. Now, the whole issue will be basically the court finds that the order of the government is not sustainable. Then my case goes. And if it finds that the order is sustainable, then obviously the second part comes whether the Anchalik Panchayat will override the decision of the government, because the government decision was on 29th
6.
and the order of the Anchalik Panchayat on the next day. So that in fact the
So
matter is
so we have to wait.
for this, that matter has been heard, I think 3-4 days back, and it is on the CF.
So we'll wait. I think it should come out soon.
It will come up. So lordship may fix it after some time so that
Okay,
we
right.
can place the order before the lordship.
Heard Mr. Y.S. Manat, learned counsel for the petitioner, who submits that the entire case, submits that the present case would depend upon the decision of a coordinate bench, who is hearing the validity of the notification dated 29/6/2024, issued by the government of Assam PNRD department, cancelling the ongoing process of settlement of ghats, huts, fisheries, ponds, etc. for the year 24-25. He submits that if the notification dated 29/6/24 is set aside, the writ petition would have to be dismissed as a natural consequence, as a natural corollary.
That will depend on that day.
That should be. Yeah. Once it goes, it has to go. Accordingly, raise this matter. When?
After
Next week.
10 days, you launch, let it be 10. CAV, we do 2 weeks.
Raise the matter on next Friday. We'll see if it's there, then we'll adjourn it again.
Interim was there.
Interim order to continue till the next day.
Mark.
Item 3.
Please, your lord.
Yes.
What?
We have received the instruction, madam. We have received the instruction, madam. And in the item number.
Admitted.
Admitted amount, my lord, that not 11 lakhs. The claim by the petitioner, my lord, 11 lakhs 53,000. But we have admitted the amount 10 lakhs 82,900.
So you pay the 10 lakh.
82.
The remainder he will go and he will fight it out in the district court. Or is it on the basis of a compromise?
Compromise.
Oh.
20%.
20%.
Oh, that 20% there.
My lord. That is.
What is this 20% business?
That, my lord, that is the meeting, my lord, that we have taken the instruction that there is a meeting with chief minister.
Actually,
and all
they
the
said
stakeholders
that
and-
if you want to get the money one time, then you come from compromise and you just take less 20%. So that was the farewell. But we have to come to court seeking the money, lordship.
They
Ultimately,
have to wait for.
we have to wait.
So what to do? Do we dispose of on the basis of that Parawai's comments or what? I leave it up to you.
Lordship, it's okay. 10 lakh something, we'll lose 1 lakh, some amount. We'll
This is the instruction, my lord. Lordship will find in the second.
Better get small amount than never, Lordship.
One bird in hand is better than two in the bush.
Lordship.
But this is actually also not very fair.
Lordship.
Unequal bargaining power. It is not allowed as per Supreme Court judgment. They are basically forcing him to take a lesser amount than he's entitled to.
Lordship, can we get a date that let them file affidavit, Lordship?
No problem.
Lordship.
Miss Udas, learned counsel for the respondent submits that para-wise comments have been received by letter dated 31/8/24, madam.
My lord, my colleague has received
Two
it,
months
my lord.
back.
My colleague has received it. My lord, I'll file it within 15 days, my lord. 2 weeks time. My lord.
Why do we,
What,
a week,
10 days time. 10 days.
Submits that letter date on based on letter dated 31/8/2024 issued by the Office of the Commissioner of Police, Guwahati, Assam. She is accordingly granted 10 days time to file the same. Today is 26th.
My lord.
List the matter on 6. List the matter on 6. 6/12. You file it by them, madam.
My lord, I'll file it. My lord, I am for 1-6. 7 is finance, my lord. Here
Okay, you say, for Miss Udas for response number 1 to 6.
Lordship, can it
I return.
can it be on
I got the
10th of December?
No, not 10th. Why 10th?
I will not be available, Lordship. I will go.
What are you going to argue anyway?
No problem.
What are you going to argue anyway? Affidavit is going to be there. Now, this is not a question of disputed facts. This is a question of admitted facts only.
6.
Lordship.
6.
Same, Lordship.
Same, my lord. We have
Letter
received
dated, same letter.
6-8. 6-8, my lord.
6/8, huh? 6/8. Okay. Same.
I'm obliged.
Obliged.
Yes, madam.
We have filed an IA today, lordship.
Yes, tell me, what is your case?
Madam, kindly pass over this matter for time being. This matter, senior counsel, Mr. I. Chaudhary will appear. Perhaps yes, senior counsel, Mr. I. Chaudhary will appear in this.
Okay, yes.
Perhaps he has some submissions.
After some time. You have got to answer some questions. I hope your senior will be coming.
Yes.
Maybe, your Lordship. Matter may passes over for time being. Or senior is one line on another court.
Item 6, yes, contempt. Yes, madam, what to do?
Lordship, senior counsel is on this. Kindly make it for a time being.
Next.
Item 7.
We have challenged the award. Thereafter, liberty was granted to the respondent to file application under section 17B. She filed an application. We file our reply. Lordship, you may please to see our reply, Lordship. 17B mandates that if employee is not gainfully employed, then she will be entitled to last down wage. She filed an application stating that she is not engaged in any way. Lordship, can please see our
Just put out the AC. Really hot.
industrial dispute 7.
Industrial Disputes Act. Yes, 17. Yes.
17B. It maintains payment of full wage to workmen pending proceeding in higher courts. Here in any case, a lower court tribunal or national tribunal by its award directs reinstatement of any workman and the employee prefers any proceedings against award in the High Court or the Supreme Court. The employee shall be liable to pay such workmen during the period of pendency, such
Yes.
in all high courts or drawn in inclusive of so and so, and allowance anywhere under the law had not been employed in any establishment during such period. An affidavit to such by such workmen has to be filed to that effect in such court. An application has been filed by the workman laws, contending that she is not gainfully employed anywhere. We file our affidavit, Lordship, may come to paragraph 5, page 14.
Yes.
We stated that I'm reading paragraph 5. Then the statement made in paragraph 3 of the application are not correct and hereby denied. I said that the applicant, Srimati Sapna Gogoi, is gainfully employed. I came to know from reliable source that the respondent number 2 is currently gainfully employed as principal in GNM Training School, Nalwadi, maternity hospital situated at Alternative Road, Nalwadi, and drawing salary approximately rupees 1 lakh per month. Under such circumstances, the petitioner number 2 is not entitled to benefit under section 17B of Indian Dispute Act. Further, Lordship, I said that the petitioner number 2 was earlier also employed in ANM FWB Training Center, Assam, India Hospital Committee, situated at Nathmuma, Sidaguri, Guwahati 38, and full-time teacher, drawing rupees 9,000 as salary per month. I further said that the petitioner respondent number 2 has made incorrect statement regarding her employment 4 times and has drawn shown false affidavit now and now and earlier also with one and sole aim to get the benefit of under section 17 of in this dispute act. So this is our contention, and no counter to this our amendment has been made by her. In my humble submission.
So she's not only she's a principal at GNM Training School.
Yeah, earlier she was there.
She was earlier.
Now she's principal at GNM Training School.
What?
Yes, sir. Absolutely. Earlier she was also training, engaged in training in some other company. Now she is working in GNM as a principal. We have document to that effect also.
Where is the document?
I made a statement that I may be allowed
Huh?
to use at the time of hearing of this application.
Why don't you how many documents are there?
Because it is a prospectus of that institute and some CDs also there.
Prospectus is not true. I can get the prospectus of Harvard University or Oxford University then.
But
Does it prove that I am a teacher there?
yes, Lord, because she, as a principal, her name is written. Yes, Lord. And no
Yes.
contract.
You know, at the time of termination of our service in 2010, my lord, I was a BSc nursing.
Huh?
I was a nurse of BSc nurse.
No, Mr. Counsel, you have got to show that you are not gainfully employed.
Thereafter, I have completed I pursued my education after my termination, and I passed MSc nurse.
So now you're employed.
I am not employed, my lord. That Nalwari hospital is my relative hospital.
Huh?
I am a qualified nurse, my lord. I may do.
Is this you? Mrs. Swapna Gogoi, Principal GNM Training School, Nalbari Maternity Hospital.
Yes.
Then?
And no reply to my affidavit has been filed till date.
This prospectus is for which year?
It is lordship of year.
22, 23.
Where do you get it? Where do you get that 22, 23? Where is it written?
What's it, maybe allowed to assist or not. Lordship, interestingly, no counter to that our experiment has been made by the petitioner till date.
So you're not filing any affidavit.
Yes, as a file reply, below. However, I am not interested at this moment below.
Huh?
Now the labor court judgment is reinstated with 50% accuracy. Now I am not interested for reinstatement.
Maybe.
I.
So you're not interested in reinstatement. So the entire, so if you're not interested, then we'll allow the appeal. What remains?
For reinstatement only, but other benefits are there.
So we will have to, then we will have to go to the merits of the case. So 17B, you want to withdraw?
No, I am not going to withdraw.
No, the 17B application.
A 17B application maybe.
Maybe withdraw. And then you want to do hearing. We can do hearing.
Yes.
You can start.
Some other day maybe for merit of the case.
Okay, right. Mr.
Yes, yes.
S. Das, learned counsel for the applicant, submits that he may be allowed to withdraw the application made under 17B of the Industrial Disputes Act, 1947. Mr. S.C. Cap appears for the writ petition. In view of the prayer made by the applicant's counsel, the IA is accordingly dismissed as withdrawn. Then in the main case, you write, on the prayer of the parties who submit that hearing can be held, list the matter on. When do you want?
After vacation.
List the matter after vacation.
Not sure.
So this is finished.
Time being item 6.
Next.
Yes, madam.
Senior is still on legs.
What is to be done? Senior is on legs.
Any other day, otherwise any other date maybe.
Where is he? Where is he? He's standing. He's on his legs, arguing. Which court?
Lordship in court number 14.
14.
No, Gina.
Huh?
Lordship, I can be fixed like another day tomorrow. Yeah.
Maybe on Monday.
Okay, right. Due to the absence of the learned counsel for the PWD.
Three.
Third of December.
This is the matter on Monday.
Third of December, yeah. Done?
Why third? First?
Yes.
Second.
Let's.
Like.
Time being item 5.
Hello, I missed the mention hours. I filed a affidavit in reply as well as an IA in this repetition because that can it both the thing can come up.
It's here.
It's a additional affidavit filed by the respondents. I filed a reply, additional affidavit in reply and an IA praying for. Can all these matters come up on today, tomorrow or day after tomorrow?
Affidavit opposition filed by response number 2, 3, and 4.
Then we filed an
This
additional.
is additional affidavit filed by 2, 3, and 4.
Yes, my lord.
What are you saying basically here?
My lords, what we've stated is basically, my lords, firstly, my lord, they objected, because in the earlier affidavit, my lord, we only pointed out, we've stated that the ONGC Jorhat is now operating 170 oil wells across the district of Golaghat. And we had only annexed one petroleum mining lease. Now, they had objected that that mining lease was only for a 52 square kilometer area. And the Golaghat is of a greater area than that. So we've annexed the other petroleum exploration licenses as well as the PMLs. Secondly, they had also objected to they had also challenged the age prescription. My lords will recall there was
Age
another.
prescriptions are decided.
Yes, now the division benches also dismissed the appeal. That judgment we've annexed. Subsequently, thereto, my lords, we carried out the draw of lots, and 49 people have been selected. Well, and the notice of awards have been issued to them. Those we brought on record.
No, the IA that I have filed, Milord, that is not before your lordship. Milord, there is serious, Milord, illegality in the draw of lots, which I have tried to bring it before your lordship.
No, no, you
What
see,
happened?
you see, draw of lots is a different issue. Right now, the issue is basically with regard to whether those persons from that particular employment exchange
Yes,
can participate in the tender process.
that is the issue in the writ petition.
That is the issue in the writ petition. Now you are trying to enlarge the scope
No,
of
what I'm
the.
trying to submit before your lordships is that, Milord, lordship will decide the entire issue. The only thing is that the I have Milord, made some arguments, or I have developed some grounds. This draw of lot is a consequential thing to the NIT. So at that point of time, during the pendency of the writ petition, the draw of lot was, Milord.
You see, we see what we can do is we can decide the first issue as to whether there is any illegality with
both the issues, lordship will
no,
decide,
no,
Milord.
no.
Because
In the other issue, when draw lots are there and persons have been selected, and those persons will have to be made parties.
And I have an answer to both. They are alleging against two persons. One of them we have rejected. After examining, draw of lots, she was selected. But when we examined her documents, we found that she does not fulfill the criteria. She has been rejected.
Okay.
there is the case.
There are
Milord.
two.
This rejection has got a
No,
In any case, by way of an
Yes.
IA, without amending the writ petition,
Ah.
can the width, length and breadth of the writ
Correct.
petition be
No,
increased
these are
like
two different causes of action.
entirely different cause of action?
It's two different causes of action. The first, if you want, you can withdraw this writ petition because frankly, I don't find it clear. You can withdraw this writ petition and make a challenge afresh on the draw law. That is a different cause of action. You cannot enlarge the scope of the by mixing up the two issues. Because the draw lots will be a consequence to the decision to be taken with regard to this case. Because if we hold your case to be correct, then if that person who has been selected falls from that area, that stock exchange, which you said should not be considered, then there's no need of filing the case against the draw of lots. Now, is it your case that the person who has been selected, he is from that stock exchange which you want excluded?
Milord, that information is not available with
then-
me.
Then where is the connection?
No, that is what I'm saying.
You see,
That
you
information is-
see, just
I'm
a
sorry.
minute. Your basic case is that the persons who are registered with the Golaghat District Employment Exchange, they should not be included.
Operational area.
They should not be included.
Yes.
Now, is it your case that those persons who have been selected in the draw of lots are from this stock exchange?
So that is not disclosed by the respondents.
So, if they are assuming that they are from this stock exchange,
Yes.
that means there's a connection. So, the second case regarding the draw of lots will depend upon the decision of this case.
That is what I am saying.
Now,
Milord,
number
lordship will
two,
take
no,
up both the
number
issues.
two, no. Number two, if those persons who are selected are not from this stock exchange, then there is no connection between this case and your reply affidavit.
That fact is not there before your lordships, my lord, whether who.
So that is why please file a separate writ petition. Please do not try to confuse the issue. You're confusing the issue. That's the thing. If you are not understanding what I'm trying to project,
That's.
then
I have
I can't
understood,
help
my
it.
lord, but what
Yeah,
is important for me, that's why I have
because
understood.
they are two different issues. The issue is the persons who have been selected, you don't know from where they are. Correct? According to you, you don't know from which stock exchange they have submitted their candidature from.
Because it has to be furnished by the
Correct,
respondent.
correct.
Yes.
So as on date, since you do not know, there is really no connection of those persons with the present case. Then
In a way, lordship is correct.
correct.
Because
I am
without that
correct.
knowledge, whether
correct.
from that employment exchange somebody has come within these 49 people or not.
Correct, correct, correct.
Without that knowledge, my lord,
Correct.
it will
So
be difficult.
that
for
why
the
don't you file a separate writ petition for them?
my lord, can they disclose this whether within 49?
Has he,
whether-
has he, has he put it on record that he has filed an RTI or something and we have not
No,
furnished?
that's a different thing altogether, my lord.
This is not the,
No. RTI,
We
I
cannot,
always file, they can conclude
that roving inquiry, we cannot have do
it's
on your behalf.
Since a question has fallen from your lordships, question is.
Question has fallen to make you understand that your affidavit in reply, the contents of your affidavit in reply is a completely different cause of action from your cause of action projected in the writ petition. That's all. So, also I am going to decide only one thing here. I am only going to decide whether those persons from that Golaghat Stock Exchange can participate in the NIP. And I will clarify that you do not know whether those persons who have been selected in the draw lots are from this stock exchange. That you can file a separate writ petition if you think that they are from this stock exchange. Supposing they're not from this stock exchange, then what happens? How do you try to put in that case into this case? It's completely different issue.
No, mainly because the draw of lot has happened after filing of the repetition. And someone from that particular exchange has been selected or not selected. That will not, my lord, dilute my challenge to the condition because I challenge on the.
Correct. That is why the
I
challenge to the condition is a separate issue.
I challenge on the ground that there was discrimination. In Sivasagar, they have followed the principle operational area and they have given the areas. Whereas in this particular NIT, they have given the employment exchange. Their operational area as per their own affidavit is 52.12 square kilometers. And Golaghat district is 3,000 odd square kilometers. So they cannot go beyond their operational area, 52.12 square kilometer, and include the entire.
You mean operational area everywhere will be the same area? Will it be same?
No, they say 52.12 kilometer operational area in their affidavit. I am not saying.
The Golaghat.
Golaghat of Jorhat.
But they are asking for candidates from 3,000.
Yes. Golaghat is of 3,000 odd kilometers. When it goes up to Nagaland border here, Milord Kaziranga. And they are saying about Jorhat asset.
But how does it cause prejudice to you? What right of yours has been violated?
More competition. Because
More
your whole
competition.
idea. No.
That is the basic thing. More competition. That is.
I must admit, Miller. I must really submit. Because your whole idea is to, of your NIT is to generate local employment. You conceive this draw of law.
So local employment, they say Golaghat district.
Operational area as you have done in Sivasagar.
But how does, okay, supposing it's a mistake. Supposing it's a mistake. Will a mistake vest you with any right, legal right?
No, it's a wrong decision, Milo. That has to be corrected. If it's a wrong decision, then it has to be corrected.
Unless there is some prejudice caused to you.
Prejudice is caused, Milo.
Unless some right of yours been violated.
my lord, prejudice is definitely caused in the context that had there been confined to, my lord, lordship will appreciate one thing. We were not allowed to participate in Sivasagar.
You challenge that.
No.
You challenge that. Then you have got, you can say, Article 14 has been violated.
Look, that is what I am saying.
No, you see, you have not been allowed to participate in Sivasagar. You can challenge that. But here, you cannot say that
Look,
these
the
persons, they
Sivasagar
are.
matter has been already been challenged, and that has already been, my lord, single judge has decided, and it has further been decided by the honorable division bench. So the scope is absolutely
Gone.
there. So I have to confine my thing only to this aspect of the matter. And apart from that, in the draw of lots, my lord, what happens? My senior has said that they have cancelled. My lord, in the draw of lots, the serial number 2, she is a lady from Gwalpara. Lordship will appreciate the sanctity of the draw of lot. Serial number 2, who got selected, she is a lady from Gwalpara.
Okay.
How?
So she's not from this. So she's
No.
not from this stock exchange.
No, and we don't know how many.
So that Golpara ladies case does not come within the ambit of this case.
No. But that's what I wanted to bring it to you before your lordships.
So please file a separate case for that. You cannot mix up the two issues. This case only pertains to that Golaghat stock exchange, that particular stock exchange, district employment exchange.
This is prior to, this case was prior to the draw of lots. I am just placing before your lordship the illegality that has been done in the draw of lot also, because in the draw of lot, that second lady, she was from Gwalpara, and we do not know how many such person has been included. And on top of that, they say they try to justify this serial number 2 by saying that we have cancelled and we have given that place from the waiting list. How can this happen?
I don't know. That is a different issue. Out here, the only issue is.
So that's why I'm saying, Milord, Lordship will kindly take up the IA, or let me.
No, I'm taking up the entire case. Why should I do it in bits and pieces? Let us, it's going to.
Can it be taken up in the next week? I file a writ petition. Both of them can be taken up together, Milord.
No, we'll decide this matter first. This is a completely different issue. I'm not going to. We cannot confuse the two issues. That, you see, the first issue is basically, this issue is out here is whether persons from the district employment exchange Golaghat participate in the tender process. That is the only issue. Once we decide that, then the second issue of draw of lots and who are the successful tenderers pertaining to that Golaghat stock exchange can be taken up. Now, those persons who have been selected in the draw of lot, some persons might be from Golaghat stock exchange, some persons might be from, like you said, Golpara stock exchange or some other stock exchange. Now, those persons are different. They have got nothing to do with this case. So we cannot confuse the two issues. We have got to be very clear on that.
Ultimately, even if I file a writ petition or IA, both the issues has to be taken up separately.
Correct. So why if it has to be taken up separately, why is your writ petition and your affidavit in reply taking up two different causes of action?
Since it's a matter of only 5-6 days, that's why I'm praying that instead of deciding this, Lordship will take up that whatever I'll file, Milord, along with this. So to just postpone this by 5-6 days in the next week, Tuesday or Monday, any day convenient, so that I can do the changes.
Convenient today. You see, it's a problem for us every time we have got to read the files. It's not that we go home, twiddle our thumbs and watch Netflix. We have to come prepared also every time. And it's not 1-2 cases that we have got to read every day. We have got to read the entire bunch.
That's true.
Then
it's a painful.
Very painful.
Yes.
What do you think? And your case is crystal clear. There's nothing, like you have said just now, you have admitted to the fact that the cause of action in your writ petition and the cause of action in your affidavit in reply is different. If it's different, why are we trying to take up both different issues at one go?
No.
We will decide one issue first, then the other issue with regard to successful tenderers that we will take up separately.
affidavit in reply, my lord, I have dealt with this issue also.
Then we'll take up only this issue.
So-
You know the case, we'll take up this issue. And with regard to your new issue that you are seeking to raise, that I will clarify in the judgment that you can file a writ petition, separate writ petition.
Fine,
Can-
then lordship can
yes,
take up.
yes,
Yes.
you can take up.
Two basic grounds urged herein is that one is age limit. Lordship says, although my lord expressed that age limit is gone, but even then I'll make my short submission on that. These petitioners, my lord, they are providing the vehicle from since 2003, my lord, for last 23 years. NIT, your lordship will find page 71. Dated 10/10/2024.
Yes,
Total page 72, your lordship will find total 52 numbers of vehicles.
yes,
Then page 79 is the age limit. They have provided age limit for the tenderer, my lord. Clause 2.2, third paragraph. Applicants falling under 18 to 55 years on the original closing date of submission of application against the tender will only be allowed to participate in the tender. This is not a tender that one who gets the tender, he'll have to be a driver and he'll have to drive the vehicle on his own. These tenderers are not drivers, my lord. Neither the previous one nor the present one.
but they are the
So-
bidders, the applicants.
Yes, they are the bidders. So now the question is, you can very well fix an age limit for the driver. But for the tenderer, you are fixing an age limit. You know, in my respectful submission, that is unreasonable. It cannot happen. Merely because I am 55 or 56 years of age, you disqualify me to participate in the tender process. But in my respectful submission, this is absolutely unreasonable. Whatever justification you give, that age of retirement is 60 years, this contract is 55 years, my lord. In the other case, they have placed those reasonings. In my humble submission, my lord, this is absolutely unreasonable. Now, the second contention that is on which I am challenging is that page 80,
Yes,
applications from individuals having valid employment exchange registrations pertaining to Jorhat, Golaghat district.
no, page 80.
Page 80, my lord, clause 3.0. Brief selection procedure for award of contract. Applications from individuals having valid employment exchange registrations pertaining to Jorhat and Golaghat district, i.e. following 4 exchanges shall only be accepted. District Employment Exchange, Jorhat, no problem, my lord. University Employment Information Guidance Bureau, Jorhat, no problem. Serial number 3 is problem, my lord, because this is beyond operational area. This is our submission, my lord. Because operational area is Merapani, Sorupothar, Borpothar and Khoraghat. And there is no denial of the fact by the respondents in their affidavit in opposition, because they haven't filed a parawise reply. They have filed a consolidated reply wherein they only say their version of the story. There is no denial of this fact. Now,
what do you mean this is beyond operational? What is the operational area?
we have stated, my lord, the operation area in our writ petition, that is, your lordship will find para 11.
and there is no reply to this particular para 11 by the respondents. They have filed a consolidated reply wherein they have said that we are allowed, our operational area is 52.12 kilometers. So we'll include the entire Golaghat, which is of 3,000 square kilometers. So there is no denial. So our problem is that serial number 3 in page 80. Now the Lordship will kindly come to the Sivasagar tender. Page 190, I'm sorry.
119.
190.
Yes.
Third paragraph, my lord. The line starts from the selection shall be
190.
190, third paragraph. ONGC Assam asset invites.
Yes.
Then the line starts as the selection shall be.
Yes.
The selection shall be restricted only to 4 locations: Sivasagar, Nazira, Sonari, Moran. The Lordship will find here they haven't mentioned about the employment exchange. They have mentioned their operational area.
Where does it say operational area?
It's in Sivasagar. And page 198, your Lordship will find the same thing. It's clause 3.0a.
Page 198.
198. Applications from individuals having valid employment exchange card from employment exchanges of any of the following areas shall only be accepted. This 4 area. It doesn't say about 4 employment exchanges. This means they intended to confine themselves to the operational area. Because of which we could not go there and participate. Why these 2 standards?
This is for Sivasagar.
This is for Sivasagar.
Page 190 and 119 for Sivasagar.
Yes. So in one NIT, you have confined yourself to the operational area wherein your operation is going on in Sivasagar, but you has widened that in Jorhat by including the entire district of Jorhat and Golaghat. You have included 2 districts. You have violated your own procedure of operational area. Because in para 11 of the repetition, my lord, I have shown to your lordship the operational area. And
out here, it does not say operational area, it says areas, that's all.
no, that is the area of operation of Sivasagar, page 198. That is the Sivasagar asset area of operation. Whether they use the word operation or area, that is where they function. That is the area there, because it has to be allotted by the government of Assam.
And does the NIT in which you are interested in say anything about operational area? Nothing.
It say about employment exchange. It doesn't say about the operational area. My question is, why these 2 different standards in similar type of NIT?
I don't know.
That is what I'm saying that this and in the condition in NIT pertaining to Jorhat, Milord, it's discriminatory, Milord. They should have restrained themselves like
It should be restrictive.
restrictive to the operational area.
But they have not used the word operational area.
Even then, they in their affidavit, in opposition, they say that our area is 52.12 kilometer.
Which area?
ONGC Jorhat Asset.
Huh.
It's called the office. Their area is 52.12 square kilometer.
ONGC Jorhat
Asset.
Jorhat Asset is
52.12 square kilometer.
And
Yes.
Golaghat?
Golaghat is of 3,400. I'll just place me. The 3,502 square kilometer. So you travel to the Nagaland border also, and you come to this Kaziranga also for this tender. And you are saying in your NIT that we are encouraging the local unemployment. So that's
So they are taking it in the context of 2 districts of Assam.
no, that's true. You take it since your operational area is covers 2 districts or includes 2 districts. So you confine to your operational area. Why you have serial number 3? Why you have gone beyond your operational area and invited applicants to participate? You should have done the same thing. That
you mean to say that Golaghat Stock Exchange people should not be able to participate in the operation area of Jorhat Asset area?
No, Jorhat is fine. Jorhat Asset is, yes, Lordship is correct. Lordship is correct. Yes, that is my thing. That Golaghat Employment Exchange, because all the 4 operational areas I have mentioned in para 11, those fall under the Employment Exchange serial number 4. That is Dhansiri, page 80.
Dhansiri is of Golaghat district.
Yes.
Then you have got no problem with Dhansiri.
No, we belong to Dhansiri.
Oh.
How can I have problem?
But then this employment exchange Dhansiri is of Golaghat district.
Yes.
This is not of Jorhat district.
No.
Then why should you be allowed to participate also?
Because
you belong to the Jorhat Asset area.
No.
Then
because we belong to the Dhansiri Employment Exchange and we fall under this 4 operational area also. We are the residents of this 4.
But
we belong to this area.
You are from another district altogether. You are not from Jorhat district.
No. The name is Jorhat Asset, but the area includes places of Golaghat also.
Okay, Jorhat Asset.
Square kilometer is not only in Jorhat.
Okay, Jorhat Asset includes parts of Golaghat district. Golaghat district, including number 4.
Yes.
Including this Dhansiri.
Yes. So our pleaded case before your lordships is that your 4 operational areas, which is equal to 52.12 square kilometer, you should have confined.
From where do you get that?
Which, Milord?
From where do you get that? The fact that Jorhat Asset area includes these Dhansiri.
Milord, I have made categorical statement.
Your statement has to be based on something.
There is no denial with regard to
no, maybe not denial, but you have got to. That doesn't mean that I have got to accept whatever you say as the Bible truth.
No,
as the gospel truth. You have got to convince this court that whatever you are saying is backed up by some document or some proof. Just because you say something doesn't mean that I've got to accept it. So please convince me that what you are saying is correct.
they have given their operational area in their affidavit, but it will not be able to understand that, my lord.
Correct. And now
Because
I,
it is some-
you have not been able to convince this court
Yes,
that what you have said is true.
I understand, my lord, but
You
if your
will-
lordships,
and you have got to stand on your own legs, not
Yes,
on the
yes.
weakness of the others.
because this technical information, what the permission central government and state government has given to the Golaghat to extract oil from the area, which is the area, it will be very difficult for me to have that information.
Then
But they have given,
and you're the counsel who's going to lead me to understanding.
yes,
Then one blind man leading another. We will probably go up the wrong garden path also.
no, I'll just try to. In their affidavit, they have given two documents. But these are page 265, map of Golaghat district PML.
Hmm. 265. Yes.
Starts, they have given map with some, codes. This is,
How does it help you or me?
and page 263, my lord will kindly have, they said that their oil exploration is confined to 54.4 square kilometer for a period of 20 years.
Applied for conversion of Golaghat district sensor to Golaghat sensor. So everything is Golaghat, nothing about Jorhat in fact. That
Since we
So-
belong to Golaghat,
you belong to the Jorhat asset area, according to you. You do not belong to Golaghat district.
This is where my learned friend has been perhaps getting a little confused. Our Jorhat asset includes both Jorhat and Golaghat. Then we are like when we loosely say Assam asset, that includes our Jorhat, Sivasagar. Generally, widely we call it Assam asset. Similarly, when we call it Jorhat asset, that includes both the districts.
Okay.
That is why we have included districts from employment exchanges from Golaghat. We have operations in Jorhat district.
Where can we have that document showing that Jorhat asset includes?
It's a period stand.
Please stand. Okay. Fair?
But in fact,
Tara?
if your lordship will kindly have our if your lordship first takes up our affidavit in opposition,
Yes.
para 13, page 220.
Yes.
Right at the bottom of that
Yes.
page,
Yes.
last sentence. At this point in time, has my lord got it?
Yes.
At this point in time, the Jorhat asset of ONGC is operating more than 170 oil wells in Golaghat district. Clause 43 of the special conditions of contract at page so and so, we have reproduced that and we have indicated which are the areas in Jorhat district and which are the exchanges in. Then if your lordship takes up.
No. Where is it that it says that Jorhat district? Okay. Okay, here. Para 14.
It includes both one.
The operational area of the Jorhat asset of the ONGC also spans the entire Golaghat district.
Yes.
So spread over Borhola, this 221, my lord, para 43. Spread
Para?
over page 221.
Yes.
My lord, quoted portion. The operation of ONGC are in Jorhat and Golaghat district and are spread over Borhola, Kasamari, Merapani, Sorupatha, Nambor, Koraghat, Field, etc. and other the districts so and so. So these are the places which I have mentioned in my para 11. That four places of Golaghat.
Interestingly, he himself is from Golaghat.
Correct.
What he is trying to say is they take X portion of Golaghat but exclude Y portion of Golaghat.
I know. No. You see, now you come from Dhansiri, Barpathar,
Dhansiri Employment Exchange.
Dhansiri. That is
Yes.
Dhansiri.
Yes. And my
Now Dhansiri, Barpathar.
yes.
Now Dhansiri, Barpathar, the name is not here in page 221.
Look, Borpathar is included.
Where?
Others are there, Lordship will say Merapani, Sorupathar,
Agreed,
Borpathar,
but then
Koraghar.
your stock exchange is not there. That is what, you see,
No, Dhansiri Stock Exchange is there already. They have said in their NIT that Dhansiri is included.
correct. But you are saying,
Area.
you see, in that way, that Golakat stock exchange is also included, but it's not included here in page 221 either. Similarly, as your stock exchange is also not included in this page 221. So you're in the same boat as that item 3.
Page 221 is not with regard to stock exchange. Page 221 is with regard to the
Area. So that is, where is your area here? Your Dhansiri or that Barpathar, where is that area here?
They did not give perhaps the entire name.
Perhaps.
Because otherwise, Koraghat,
So that is what, when you are throwing stones at that other stock exchange, that it has to apply to that same
stock
logic
exchange-
will apply to you also.
yes, Lordship is correct. But my stock exchange, there is no dispute. Nobody is disputing that the stock exchange doesn't fall under
No,
the
I am questioning you. Maybe no, he's not disputing, or anyone is not disputing. They are not disputing anything. But this court is questioning you on
Yes.
that aspect to clarify the matter. Your stock exchange, which is in Golaghat, and the other stock exchange, which is in Golaghat, they are both mentioned in the NIT. Now, in this page 2021, now, the area in which a stock exchange is situated or located, and that number 3 also, both of your names are not here. So you all are in the same boat. Why should you be given special preference? That's all. Anything else?
No, nothing, Lord. To answer to your Lordship's query is that, my Lord, Dhansiri is included.
Yes. In page 2221, it's not there.
It's not 221, but it's there in the NIT.
That way, the other stock exchange is also in the NIT.
It's true.
Hmm.
But we have questioned that stock exchange should not.
And I am questioning you.
Yes.
You are questioning them. I am questioning you.
Yes.
The question that you put to them,
Yes.
that also should be put with regard to your stock exchange.
Sure.
Why is your name not included here? Because you said the area in which your stock exchange is included in this page 221, but it is nowhere reflected. Dhansiri is not there, Barpathar or whatever is not there also.
The Koraghat, Sorupathar,
Maybe.
Merapani.
But your stock exchange is not from Goraghat or
No.
from Sarupathar.
All these Koraghat, Sorupathar, all these falls under Dhansiri.
Correct.
That's why.
This Sarupathar, all this falls under
Yes,
Dhansiri.
that is what we have said in para 11 of the writ petition. So there is no dispute, and they haven't filed in their affidavit. They haven't said that the para 11 contention that 4 places don't fall under Dhansiri. Sum and substance, my lord, my case is that you should not have gone beyond your operational area, my lord. Inviting everyone, that is my case.
Okay.
That is precisely my case.
Okay, then
Sum and substance.
that's all. That's all. What is?
In Sivasagar, you have followed that principle. Operational area, you did not follow in Jorhat.
Okay.
That is my simple case. And so far as age is concerned, even, Milord, there cannot be, in my respect, I tried to get some authority, but in my humble submission, Milord,
I think you'll have to go to Supreme Court for that. Because I'm bound by the division bench judgment.
for that point.
Maybe you're not, but I am.
That's true.
Though you might have a point, in my opinion, but then judicial propriety demands that I've got to follow the division bench judgment.
True. That's true. So this is my precise case, and so far as I could have placed those facts with regard to the draw of lots had the IA been before your
No,
lordship.
that no. Draw of lots case, so you go in, you're challenging that. Now, first of all, your case was that you didn't know from which stock exchange they belong to. Later on, you said that number 2 belonged to which district you said? Another district, different district, Golpara district.
Yes.
Belong to Golpara district. So Golpara district stock exchange is not has nothing to do.
That had happened.
That
in
nothing
my
to do.
opinion.
Nothing to do with the issue brought out in the writ petition. The writ petition is particularly only in respect of that Golaghat stock exchange number 3. So that Golpara person is a different.
Petition because it was prior to the draw of lots. Definitely
That would give you liberty to file a fresh writ petition. You find that. Cannot confuse the two issues.
No. Absolutely fine. I tried to bring it before your lordship by virtue of an IA because of their issuing the work orders and the.
If we allow you to bring it, this writ petition will become, very confusing.
So there also, Milord, I have only one point. That is this: how you bring serial number 2. And
He's from Golpara. There's nothing to do with this Golaghat stock exchange.
I understand, Milord. I am not on Gwalpara or Jorhat in that thing. There, Milord, the moment you have included one person from outside those 4 exchanges, here you have mentioned the entire draw of lot vitiated. That is
that is a different thing. You challenge that. Yeah, you have got to make that person a party also. You'll have to amend the writ petition also.
That has already been cancelled. That serial number, no. So that is not the solution. That is what I
that is a different.
persuaded.
That's all. Yes. Anything else besides that? Nothing else.
That is the.
First things first, we need to correct one thing at the very initially. We've been calling the employment exchange a stock exchange. All the unemployed people must be cursing us right now. But my learned friend came up with a very interesting argument that the driver's age can be 18 to 55. But how can you restrict it to the tenderers? My learned friend has perhaps not seen one of the clauses, page 137 of the NI. Page 137 of the writ petition.
Yes.
Serial number 13 in that page. The successful bidder applicant shall have the option to provide drivers along with the light vehicle as under either self-driven, that is the bidder applicant driving the light vehicle himself, or B, or through an authorized driver. So that is why we did not want to make any discrimination in that. That is why uniformly we have kept it 18 to 55, cutting across all, whether you are a driver, or whether it is a self-driven vehicle, or whether it is a...
Anyway, this issue already decided by the single bench and division bench. What is the division bench order?
Both are annexed.
Okay, both are annexed. Page?
Single bench is page 243.
And the division bench?
That is in our first affidavit. Affidavit in opposition filed by ONGC. It starts at 243. The issue pertaining to this age is at page 257. And then writ appeal judgment we have annexed to the additional affidavit. The judgment starts at, DB judgment starts at 298. And operative portion is at paragraph 27 at page 314.
Okay.
That settles the age issue. Now the other only
But on fact, only thing that my learned friend tried to distinguish between the Sivasagar and Jorhat asset is by saying that in Sivasagar, we simply mentioned the area without mentioning the employment exchanges. That is incorrect, my lord. Factually, if your lordship will kindly take up page 188. Page 188 of the writ petition, the other NITs pertaining to Sivasagar is annexed by the petitioners. And if your lordship kindly turns to page 198, your lordship will find the employment exchanges in Sivasagar are specifically mentioned.
Yes.
At the very top. Applications from individuals having valid employment exchange card from employment exchanges of any of the following areas shall only be accepted. So factually, it is not correct to say that we did not mention any employment exchange in respect of Sivasagar. And so far as, my lord, if your lordship kindly takes up the additional affidavit filed by us. If your lordship takes up the additional affidavit at page 274, paragraph 2, subparagraph A.
Yes.
Line about 8 from bottom in subparagraph A.
Yes.
There is a, towards the right hand side. That apart, the ONGC Jorhat continues to carry out seismic survey operations across the length and breadth of the Golaghat district with the objective of discovering new oil and natural gas reserves. We have operations throughout the district of Golaghat as well as Jorhat. So that is why we have included both the districts so that, and the local employment issue pertaining to both these districts. So where is the fault?
No, he doesn't want competition. That's
And that judgment, one cannot put it to challenge only because it does not suit you. That Balaji Ventures case, one. I had placed it on in connection with some other case also before your lordship. Paragraph 9 of Balaji.
Yes.
Now, so far as the impugned judgment and order passed by the High Court dismissing the writ petitions is concerned, what was challenged before the High Court was one of the tender conditions clauses. The High Court has specifically observed and noted the justification for providing clause so-and-so. The said clause was to be applied to all the tenderers bidders. It cannot be said that such clause was a tailor-made to suit a particular bidder. It was applicable to all. Owner should always have the freedom to provide the eligibility criteria and the terms and conditions of the bid unless it is found to be arbitrary, malafide, and tailor-made. The bidder tenderer cannot be permitted to challenge the bid condition clause which might not suit him and inconvenient to him. This is the sentence I am relying. Only because it does not suit him or it is in some way inconvenient to him, he cannot be permitted to challenge. So here, he himself candidly admits that the only problem is that there will be more competition. And as the saying goes, more the merrier.
No, but then less chance of him being selected.
That is the only problem. So therefore, my lord, in my respectful submission, the main substantial issues have been already covered by a coordinate bench and upheld by the division bench. The only issue that has been additionally raised is this. New areas, extra areas should not be permitted. That is one squarely covered by this judgment. And it is our discretion what condition to put and what not to put. We find that we have huge areas of operation both in Jorhat as well as in Golaghat. So that is why we have incorporated both the districts. That's all.
Okay.
Well, only one thing. So far as competition is concerned, our power to compete has already been restricted by putting us in the draw of lot. If they would not have done the thing with draw of lot, the ONC would have seen our power of competition. Now again, our
You
competition,
can challenge that in a subsequent writ petition.
the problem is that that was challenged in the earlier Sivasagar, that was negated by this honorable court. And second issue is that, there we lost our power of competition. Again, in terms of this area of operation, you have again, my lord, restricted us. And page 198, my senior has said that there is mention of employment exchange. There is a difference in that, both the conditions, both the tenders. It says having valid employment exchange card from employment exchanges of any of the following areas. So your Sivasagar tender is area specific, not employment exchange specific.
Anyway, yeah.
So why these two standards or two different types in both the tenders? That is my submission.
On that, my lord, assuming the worst case scenario also, the lordship is aware there cannot be a negative equality. Only because we did something else there that we'll have to repeat the same.
It's not about negative equality. It's about two different standards within 6 months in same type of tender. That was also a vehicle. This was also a vehicle.
No, why can't the authorities change their terms and conditions for different areas? Unless you can show this court that some right of yours has been violated. I don't know what right of yours has been violated. That's the basic issue. No right of yours has been violated. And this, I don't think by enlarging the scope of the candidate, there has been a violation of Article 14.
Violation is that none of the petitioners could be lucky in the draw of lot. Well, they say about employment generation. So they'll take vehicles from 52 and they will give it to another new 52. That's how the employment will generate.
Because he has been employed for the last 20 years as per his own.
Fine.
You have enjoyed it for 20 years. Now you take some rest.
How it is, I have to take rest. So how it comes to employment generation? You have replaced the existing 52 from another 52. Generation.
So if they don't select you, then there'll be newer opportunities for newer person.
So that doesn't mean employment generation. Had it been 52 to 100 vehicle, then I would have understood. Yes.
But life is like that. All over the world, jobs are going now with AI. All robots will take our place. There might not be judges also, lawyers also. How do you know?
That will not happen.
You cannot say. You cannot say what will happen in the next 50 years. You cannot say. All the you see, with so much improvement in medical terms, in your computers, we don't have the thinking capacity. I don't know. Someday
that will definitely lose in coming days, our thinking capacity. Perhaps because of the.
What about now?
But
in WhatsApp, you see this. I don't know if it's true. Robots coming out, serving things. Even in Aizawl, there is a thing. They come and serve.
In Guwahati also,
there is one like that. So then they'll become your nannies also.
But
then your household, you won't even get up. Now itself, if you've got servants, some people, they even to get up to get your remote, they don't feel like doing it. They ask their servants to get the remote. So you can imagine, with robots, so there's no complaint, nothing. They will do everything. Anyway, chalo.
My lord will give me that liberty, my lord.
That though surely, no problem. Only thing is, I just wanted to see this case. Okay, right. Heard. Mr. H.K. Das, learned counsel for the petitioners. Also heard Mr. I. Chaudhary, learned senior counsel for ONGC.
2, 3, and 4.
Comma response number 2, 3, and 4, assisted by Mr. B. Chaudhary. Miss appears on behalf of Mr. S.K. Medi, learned CGC. For respond number. The petitioners are aggrieved with the inclusion of the district employment exchange, Golagat, Jagat Goswami Path, Chan Mari Assam, dash 785621. Being one of the employment exchange from which candidates can apply for participating in the NIT number L46 BC 24007 dated 10/10/2024, issued by the ONGC, for hiring of the services of 52 brand new light vehicles, bracket taxis, bracket close, for the Jorhat, for the ONGC Jorhat asset area, for a period of 4 years. First off, the successful candidates are to thereafter be selected on the basis of draw of lots on inward commas, one application, one vehicle, bracket close, inward commas basis. First off, the petitioners' grievances are twofold. Firstly, that the terms of the NIT require the applicant to be within the age group of 18 to 55 years. And secondly, on the ground that the applications from individuals from the District Employment Exchange, Golaghat, Jagat Goswami Path, Chan Mari Assam, 785621, could not be allowed to participate in the NIT, on the ground that the said District Employment Exchange, Golaghat, hereinafter referred to as the DEE, DEE Golaghat, was not within the operational area of the Jorhat asset, of the ONGC Jorhat asset. Next paragraph. The petitioner's counsel submits that prior to the issuance of the NIT dated 10-10-2024 for inviting applications from the four employment exchanges, comma, for the Jorhat asset area, comma, the ONGC had issued an NIT dated 31-7-2024 for the Sivasagar district / area. The candidates, the applications, the applicants who could participate in the NIT dated 31-7-2024 for the Sivasagar area, Sivasagar operational area, was only for those persons who lived within Sivasagar district and who are from the employment exchanges from Sivasagar district. Full stop. However, full stop. The petitioner, as such, the petitioner being a resident of Golaghat district could not participate in the NIT dated 31-7-2024 as applicants were invited only from the operational area relating to the Sivasagar district. However, in the subsequent NIT dated 10-10-2024, the ONGC have made a deviation in terms of the persons who can apply for the NIT by doing away with candidates, by doing away with restricting the candidates from the operational area and expanding the persons who can apply from by expanding the by calling for candidates from employment exchanges beyond the operation area of the Jorhat asset. Next paragraph. The petitioner's counsel submits that persons who are registered with the DE Golaghat cannot participate in the NIT dated 10-10-2024 as the D Golagat, which is in the Jagat, which has its which is registered at Jagat Goswami Path, Chanmari, does not fall within the operation area of the Jorhat asset, while the petitioners who are from the employment exchange, Dansiri, Barpathat, Golaghat district fall within the operational area of the Jorhat asset. Next para. Mr. I. Chowdhury, the learned senior counsel for the ONGC. On the other hand, submits that the Jorhat asset includes the entire Jorhat and Golaghat area. Golaghat districts. Pusta. He thus submits that there is no infirmity. No, he also submits that the operational area of the Jorhat asset, having included the entire district of Jorhat and Golaghat, there is no infirmity with the ONGC calling for applicant from the D Golaghat.
My other submission is, Marat, even otherwise, it does not violate any of their legal rights.
In any event, no legal right of the petitioner has been violated by calling for more candidates by the ONGC. Next slide. Mr. I. Chowdhury also submits that the grievance of the petitioner with regard to the requirement of the applicants being within 18 to 55 years has already been decided by the single bench and the division bench of this court in WPC 4108/2024. Inward comma, self-dependent motor driver union and 12 others versus Union of India and 4 others, decided on 25/9/2024. He submits that the said judgment passed in WPC 4108 of 2024 was upheld by the division bench of this court in WA 365 of 2024, while judgment and order dated 8/11/2020. He also submits that in terms of the judgment of the Supreme Court in the case of Balaji Ventures Private Limited versus Maharashtra State Power Generation Company Limited and another, 2022 SCC Online SC 1967, a bidder tender cannot be permitted to challenge a bid condition which might not suit him or is not convenient to him. He accordingly submits that no case having been made out by the petitioner, the writ petition should be dismissed. That's all. Anything else? No. I have heard the learned counsel for the parties. Actually, one more thing. Petitioner's counsel. The petitioner's counsel submits that during the pendency of the writ petition, a draw of lots has been conducted by the ONGC for selecting the successful tenderer. And in this respect, some applicants have been selected by the ONGC. One of them being registered with a employment exchange belonging to Golpara district. He submits that the entire process of draw of lots being held by the entire process of selection of the successful tenderers being illegal, the draw of lots should be declared, should be set aside. He, however, submits that he does not know all the tenderers who have been declared successful in terms of the NIT dated 10/10/2024 pursuant to the draw of lots. That's all. We come back. Then I said, I have heard the learned counsel for the party. I've heard the learned counsel for the party.
Can my presence be excused?
This is clause 3.0 bracket A of the NIT dated 10/10/2024 states as follows. Page 7, no, page 80. Page 80. Actually, before that, just before that, we just put the first issue that is being taken up by this court is whether the petitioner's challenge to the condition in the NIT dated 10/10/24 with regard to the applicant's age being 18 to 10/55 can be decided by this court. In WPC 4108/2024, a coordinate bench of this court had the opportunity to decide the said issue in respect of the NIT dated 31/7/2024 pertaining to the Sivasagar district. The coordinate bench held in para 22 that the prescription of the maximum age of 55 years on the last date of submission of the bid could not be held to be arbitrary or unreasonable. The challenge made to the judgment and order passed in WPC 4108 of 2024 wide WA number 365 of 2024 was dismissed by the division bench of this court when it held that the prescription of the age limit entitling an applicant to apply in pursuance to the tender between the age of 18 to 15 years, cannot be held to be unreasonable. In view of the decision of the coordinate bench and the division bench of this court, this court holds that the age limit of 18 to 55 prescribed for a tenderer in pursuance to the NIT dated 10-10-2024 cannot be said to be arbitrary or unreasonable. Full stop. Next. With regard to the second issue, that is whether the calling of applicants from the DE Golagat was arbitrary and could not have been allowed in terms of the NIT dated 10-10-2024. It would be best if clause page 71, page 80, clause 3.0 of the NIT dated 10-10-24 is reproduced herein below as follows. It gives them. Acha, one thing earlier, the writ petitioner, you also said this. The writ petition, the counsel for the writ petitioner submits that the petitioner has been working under the ONGC by providing his vehicles as a taxi for the last 23 years. How you put that? Okay. Then next, what do I say? No, first up, he submits. Continue. He submits that with the ONGC allowing applicants from the DE Golagat to participate in the NIT, there is more competition. Which reduces the chances of the petitioners who are from a different employment exchange, from being selected. He submits that the same goes against the grain of the philosophy in calling for applicants under the NIT dated 10-10-2024 as new employment opportunities were to be provided in terms of the NIT dated 10-10-2024. Now come back. What have I said? Three point zero. Dated 10-10-24 states this one. That first part you cut, that second. Same thing. That first part page 80 you cut, the second part you put it. Is as follows. Okay. The same thing. Is as follows. The petitioner's case is that the calling for applicants in relation to the Jorhat asset area should only be from candidates belonging to the operational area within the Jorhat asset. Within Jorhat asset. He submits that though the petition, he has submitted that though the petitioners belong to the employment exchange, Dhansiri, Barpathar, district Golaghat, the DE Golaghat, which is also in Golaghat district, is not within the Jorhat asset, operation area of the Jorhat asset. On the other hand, the ONGC have stated in para 13 of their affidavit that the Jorhat asset of the ONGC operates more than 170 oil wells in the Golaghat district. And that the operational area of the Jorhat asset of the ONGC also spans the entire Golaghat district. As such, the two existing employment exchanges of the Golaghat district have been included in clause 3.0 of the NIT dated 10/10/2024, thereby giving an opportunity to the unemployed youth of Golaghat district of participating in the tender process. So stop. Next paragraph. The petitioners are apprehensive of the applicants of the DE Golaghat participating in the tender process, though the petitioners themselves belong to another employment exchange from Golaghat district, that is the one located at Dhansiri, Barpathar, Golaghat district. When the ONGC has categorically taken a stand that the operational area of the Jorhat asset of the ONGC also includes the entire Golaghat district, no fault can be found with the calling of candidates from the DE Golaghat also. Next para. A perusal of the NIT dated 31/7/2024 pertaining to the Sivasagar district also shows at clause 3.0 of the said NIT that applications had been invited from the employment exchanges of number 1, Sivasagar, number 2, Nazira, number 3, Sonari, number 4, Moran. Thus, when applicants have been called from employment exchanges for the operation area of the Sivasagar district, this court is of the view that there can be no infirmity in the calling for candidates from employment exchanges registered in both Jorhat district and Golaghat district when the operation area of the Jorhat asset includes both Jorhat and Golaghat. In view of the reasons stated above, this court does not find any infirmity. No, for some reason. The above being said, there is nothing to show that any fundamental or legal right of the petitioners have been violated just because applications have also been called from candidates belonging to the DE Golaghat. As it is settled law that to have cause of action, the petitioners would have to show that some legal or fundamental right of theirs, some enforceable right of the petitioners have been violated, the inability of the petitioners to show that their rights have been violated just because there is going to be more competition, the attempt by the petitioners to restrict the field of competition in the manner sought to be done is not sustainable. In view of the reasons stated above, this court finds no merit in the writ petition. The same is accordingly dismissed. Full stop. Next para. With regard to the submissions made by the learned counsel for the petitioner, that the draw of lots, the selection of the successful candidates by way of draw of lots should be cancelled. This court is of the view that the issue sought to be raised by the petitioner at this stage is different from the issue raised in the writ petition, in the main writ petition. As such, the petitioner is given liberty to make any challenge to the selection of the successful candidates. . by way of a separate appropriate petition, comma, if so advised. That's all. Actually, one more thing, just before that, before dismissal, in the case of Balaji's Private Limited Supra, the Supreme Court has held that the owner should always have the freedom to provide the eligibility criteria and slash or the terms and conditions of the bid unless it is found to be arbitrary, comma, malified and slash or tailor-made. Full stop. The bidder slash tenderer cannot be permitted to challenge the bid condition slash clause which might not suit him and is not convenient to him. Full stop. This court, on considering the above facts, is of the view that the condition allowing for applicants from the DE Golaga to participate in the NIT dated 10/10/24 is not restrictive in nature and is in fact in tune with Article 14 of the Constitution. First of, as such, the challenge made to the terms and conditions to clause 3.0 of the NIT by the petitioner is not reasonable or sustainable. Put this over. This also. This also. Okay. I don't know if we'll have to be able to do this. Talk to them because 3:15 I have to get on that.
My lord, in this case, I monitor action one A has been filed for implement of the 103 numbers of the assessment members in this case, because we are ready to accept given a benefit. Whatever might have my.
You are ready to accept the settlement.
So as per your lordship direction, my lord, we have exhausted all the dates, my lord. The lordship has announced an earlier order that we should have proposed to the company or to the association regarding our intention to pay this thing and withdrawing the penalty from the association. So we have exhausted all the things. So our prayer is I will be impeded. So we are not contesting the case and we are ready to accept it. All India has no objection in that because the settlement relies them by filing a reason affidavit. That settlement we are educated. Earlier order, it is.
Why should we implead you? What is the requirement of impleading you?
Because the case is otherwise contesting for a long time because most of the members have already, some have died and some have retired. So if it's getting the benefit by in the lifetime, it is a meaningless. So whatever we are getting.
So you are part of which petition?
Respondent number 3, minority.
You are members of the respondent number 3.
Yes.
So what is the requirement of impleading your?
Because if we are not accepting, we are not express our intention to accept this because this case is contesting, they are not ready to accept whatever the offer is being made by order. So we are ready to accept.
So Mr. Dasgupta, you are appearing for respondent number 3.
Yes.
Is it? Now, what do you think of their prayer? There are 103 members of your members. So they are saying that they don't want to be part of the proceedings anymore. They are willing to accept the settlement being offered by the TSC. By the All India.
Yeah, I have not received the application. I have not received that copy. Not allowed.
No, আমার response number 3 diyan. Actually, you don't know that one.
So you have submitted your withdrawal from the membership
Yes, sir.
to them. And they have not taken a decision.
They are not taking decision. And the Malad, All India Malad, they are saying that we should approach the assessment. We have already adjusted Malad. And the second thing, Malad, the as party.
So you give him a copy of your petition.
Oh,
if you-
yeah.
So what to do? And you take a decision on their application for membership withdrawal.
Actually, I have not received that copy.
What?
No, copy one I copy has been received.
Now, another thing is that how many members do you have in your association?
More than 700 something.
More than 700. Out of that, how many active members are there? Others are the wives of the earlier members still party to your association or what?
Some are retired.
Some
Some
are
of them
retired.
retired, some of them died. Even though earlier one of the 4 member approached before also. One already died. Meaning that she was 4 months kind of.
Okay.
Our citizens are there. We have some thinking about their future. So we are contesting the case, we're not getting the benefits. That is why we're ready to accept the whatever we are getting. We are happy to get it.
But why should
Probably because of the fact the case was filed in the year 1978 to 2017. Now 2014, they are not getting the benefit of that order. Probably for that reason they filed matter. I don't know what is the content of the application.
Because after that, if we go, every possibility, some order has been passed. If the agree party will again go to the division bench, then again go to Supreme Court.
Because of this law.
they will go, they will.
That is why.
That is for sure.
It's like, we are whatever we are getting, we are happy.
Mr. Goswami, what to do now?
Take some, yeah, don't think
Leave. Only thing is that he is praying for impleadment in this petition. What is the requirement?
I will not implement, then they are our name will not be taken. That is the Lord.
Okay.
Uh-huh.
So we'll implead them then.
No problem. No, actually, copy has to be served to us.
I'll serve.
I don't know the content of this.
Or instead of that, instead of impleading you, you give a copy to them, let them obtain instructions with regard to your application to withdraw from the association.
Yes, sir.
And if they bring a letter, they come up with the instructions that they are accepted, we'll record that and we'll close this.
Yes,
So you don't need to get impleaded.
That will be better.
They don't want to participate in a particular activity.
Yes, yes.
Once you are a member, it will always be a member.
Correct. No, you see, the reason is they want the order from this court so that they can take advantage of your settlement.
Yes, probably that is the reason. Because of this long pendency.
Correct. So that the problem is the association is not giving them that acceptance. Huh? Not required. Okay. Okay, then, Mr. Counsel, why don't you, on the basis of your petition and the order that we passed today, why don't you submit a letter to them?
Kindly problem is because of this thing, kindly have a look my, I am page number 50.
50.
Yes. This is the problem.
I have to ask them.
Yes.
It has been issued by the chief manager, for the general manager, Indian Oil Corporation.
Yes.
Whereby it is logically come to a 3.0.
Yes.
Whenever our representation was considered, then this was the observation. Additionally, as per the para 17 of the aforementioned MOS, it stated that the benefit of the MOS will not be applicable to those listed WCL, whose demand for same and similar wage and benefit and demand for the regulation are subsidies before the Honorable Guwahati High Court until the outcome of the concerned court case. Moreover, 3.1, my lord. Therefore, before any further steps can be taken, you are requested to first approach
the Oil India Vikas Committee from the to formally submit a prayer to leave the union as it is consistent with your submission before the court. Well, here, well, the ground was that if some case is pending regarding this similar pair or other thing, so that is not applicable in my case because our this type of case is not pending for any other regulation.
Whatever it is,
So they are saying that we approach, but we have approached. It is already exhausted, my lord. But that was even.
no, so you have to approach the OITSS. So you have approached.
I have
Now, once you have approached, so you forward, then you submit a subsequent application to the Oil India with your application to withdraw from the membership and ask for your settlement.
One pair I think. We got civil kind of in that way, thinking about this thing. Then, my lord, I may be given a liberty. Then to file the all the annexes of withdrawal to close to the oil. And according
No,
to
no,
our-
that is not required. We can check it out. We can say, yes, they might have reason. Only thing is I may
that may be-
have to sum the instruction. This much. We may agree with this, their proposal.
You have to agree.
Yes.
You can't say that you have to remain.
Yeah. So,
That the benefit will come in that way also.
hmm.
We have tried. We have tried. We have tried.
Then, okay, right. Anyway, he wants an order from the court, basically. So that there is proof that they are the ones. Okay, right.
That copy.
In the IA.
Copy of this.
You come to page, Mr. Dasgupta, you come to page 59, 58, anyone? 54, anyone?
These are the resignation letter.
So they're resigning, that's all.
We all resign.
No, if they want to resign, we cannot prevent them not to be resign.
Correct.
But the only thing is that I have to some instruction in this.
No, so the only thing is that we will direct that since they have issued a resignation letter, application for resigning, then if you issue a consequential letter to them, that's all.
They can
That doesn't
approach the Oil India,
Huh?
or they can approach the Oil India so that the settlement may be applied on
Correct.
them.
But you submit, you issue a letter so that we know that they are really members of your association, or there might be some third party people, we don't know.
Yes, that is why I want to be, I want to be on the safe side.
I do not know. I do not know.
I am coming out my lord.
I don't know. You could be someone from somewhere else, never a party to this. I don't know.
Otherwise, the oil will not give the benefit because we are claiming that we are.
So oil can always ask from the association or.
They are not a regular worker, the benefit will not come to you.
Okay, right. Heard Mr. P. Mahanta, learned counsel for the applicants who submits that the applicants were the members of the Oil India Thika Shramik Sangha, bracket OITSS in short. He submits that the applicants are desirous of accepting the terms and conditions of the memo of settlement dated 9/11/2022. And in pursuance to the same, the applicants have submitted letters stating that they intend to withdraw their membership from the OITSS. Next one. The petitioners counsel submit that the 103 applications for withdrawal from the OITSS has not been answered by the OITSS till date. Question. Next one. Mr. P. Mahanta, the learned counsel for the applicants further submits. AC. Very hot. Which is that page you were referring to?
This is the IOC letter, madam. That is the page. Like extra copy as
Let it go. Give me a copy one.
Is there a second copy here? We don't have second copy. No. Huh? Only I one I only, no second copy. For give to Mr. Das Gupta. You don't have.
Hey, all right. Yes.
Which page?
On the page 50.
51.
I
Not 51.
I
50. Submits.
Page.
That in terms of the letter dated 21/10/2024 issued by the Chief Manager HR Relations for the Chief General Manager HR Relations, page 50, huh? The benefits of the memorandum of settlement can only be granted to those persons who first submit a prayer to the OITSS to leave the union. Next part. Mr. P.K. Goswami, the learned senior counsel for the Oil India Limited, submits that he has got no comments to make with regard to the applicant's request to leave the membership of the OITSS, as that is a matter of choice of the applicant. Mr. A. Das Gupta, the learned senior counsel for
That's
the,
number 3.
that's point number 3.
That is the OI. Yes.
Submits that if the applicants have submitted applications to withdraw from the membership of the respondent number 3, the respondent number 3 shall issue appropriate replies to the same within 1 week.
Within 3 days. All right, no problem.
Within a week.
15 days, why? 10 days.
Huh?
All right, within a week.
Within a week.
That will be
from today. Awesome. Next. In view of the fact that, in view of the stand taken by the respondent number 3's counsel, that the reply to the withdrawal of membership by the applicant would be answered to within 10 days, there is nothing to decide in the present application. The application is accordingly closed. Dismiss. What? Close. Close. What is there to decide otherwise? There's nothing. That's all. I think. What else do you want?
After that, oil.
That you file an application with them. Full stop. Next, before close, is it? The question as to whether the memorandum of settlement, the benefits of the memorandum of settlement can be granted to the applicant's hearing would depend upon the application and the required documents to be submitted by the applicant to the Oil India Limited, who shall take a decision on the same as and when an application is made by the applicant. That's all. That's enough, Mr. Goswami. The application is accordingly closed. Little bit of correction here and there are made. Now, with regard to this, now you see, this court is rising at 3:15. Unfortunately, for the next 3 days, we have got interviews. Yesterday also we had interview. So I don't think you all will finish in 1 hour. This case is not what to do. No time. Next week. Huh? Tenth, I'm not free, huh? 10th, I'm not free. Few, not much, very less case, not long matter.
Hey, copy of the writing up. Hey, copy of the- A copy of this application may kindly be served on us.
Yes, Mr. Manta, can you give copy of the application? Yes, sir. Just give it to them.
Photocopy file and make the available.
You see, all the applications are not here. Your application for your application.
No.
From leaving the respondent number 3 is not.
That is why I specifically categorically stated that we have all five. That is only specific number we have.
Okay. Listen, you.
Their name will be included, will be figured in this application. We can check it up in by that way.
So what to do, Mr. Goswami? We'll have to fix another date. Because I don't think you all will finish in 1 hour. Huh? Because our interview starts at 3:30. And our interview takes a long time. So when do you think we can do it? Otherwise, Mr. Dasgupta, you're ready now. You're ready with the case.
To some extent, we are ready.
How long will you take to?
That depends on his argument.
He'll take only 1 hour at the most.
So what he says, that is that. It
Because
may not take 1 hour, or it may take 1 day. That is dependent.
When do you all want? Because today is what day? Huh?
अपनी क्या लोग अपनी very short date, no?
You tell me.
5th December.
5th December.
Only thing because I have a matter of fixed import 1 on 17th, apart from that date and.
Hey, he took it.
What about that date?
5th.
5th December.
Is it all right? 5th December. Because I am right at 3:15. You all will not finish. Huh?
Because union members are being forced to sign settlement. To get the benefit. So this is what is happening.
Well, this matter has been pending for how long?
Because of long pendency, this has happened, Millard. Only because of the long pendency for this one. Matter was filed in the year 2017. Now it is 2014. Now what the poor people will do?
Probably after I retire also it'll still be here.
What the poor people, they are compelled to do so.
Not because of this hearing. It has started in 17th.
They got a stay order.
They got to stay out. That is hearing has been.
You see, it's not that the council is there, all of you all are ready. Only problem is that the time is not there. That's it.
Possible fix the matter the state so that it can be.
Otherwise, a large number of members will go.
Not the number of members they are forcing. I mean, more delay is better for the.
Better for them. Better for them.
All is fair in love and war.
My lord, only the blame.
This is the. This is another way to do frustrate the impugned order.
No, no, what to do? When you,
Leave it,
so
Your
fifth,
Lordship.
he's saying fifth.
Responsible for what is happening.
We will not take-
That I can't say. Who is responsible or who is not. We have to inquire about who is responsible or not.
Okay, so we'll do it on fifth.
Let it be before 12, before 2.
As you petition, I have no problem.
We won't fix the time.
Yes.
Well, you can, well, we'll fix that too, but you can mention.
Not fixed to, before that, it can be taken to not.
We'll see.
So that it can be
You
finished.
just make sure that we don't fix too many cases there.
On that day, we shall try to finish this matter.
Might have been fixed. That's what we don't know now. That's the problem.
Fixed on fixed, it can be taken.
Or let it be fixed any other date.
On the parties,
Subject
the
to
matter on
Lordship,
fifth.
convenience of the Lordship.